Hold on just a second. Mr. McCoy, what is the problem? Have a seat. I'm trying to have hearings. You talk to me, I'll call you up in just a little while. I don't care who you're talking to. You're bothering me right now. Y'all sit down and be quiet. And no, just wait. Mr. McCoy. This is State of Florida versus Devontae McCoy, case number 24 CF 2543 and 2544. Mr. McCoy, as representing yourself, Mr. McCoy, do you wish to continue to represent yourself?
Yes, sir.
You know, at any point in time, you can ask for an attorney to represent yourself or to represent you, and one can be appointed to represent you. Is that correct?
Sir.
Okay.
Yes, sir.
All right. What are we set for today?
I believe it was set for a motion, but I had contacted the Selfco CEO. They never replied, so I'm still waiting on my videos to come in. He said he will be sending them to me, so.
They are going to send them to you?
Yes.
Do you want a pretrial set on this, or do you want to set it for a motion hearing?
Probably a motion here.
I'm going to set it for the April motion. That'll give you sufficient time. April 8th. No, that's April 17th.
All right, guys, lock in. This is State of Florida versus Devontae McCoy. Case numbers 24 CF 243 and 2544. Now, McCoy, he's rolling solo, no lawyer. He's invoking his right to represent himself, but the vibes, tense. Real tense. The court's trying to set a motion hearing, but McCoy's throwing up a red flag. Says he's still waiting on critical video evidence that never showed up. That's not a minor detail. That's the foundation of his defense. Still, the judge locks it in. April 17th, 1:30 p.m. Mark it down. But here's the kicker. McCoy doesn't even seem to know who's actually handling his case. The defense is like a GPS with no signal. Spinning in circles, no direction, total confusion. We're only at the starting line, and this thing's already off the rails. Pure courtroom chaos from the jump.
Yes, sir. Do you know who's the state attorney in my case?
Who's the state attorney?
Technically Mr. White, but for now, I don't.
Your guess is as good as mine.
Because Miss McAfee just McAfee.
She's in another division now.
She just accepted my motion like yesterday, the day before. I figured she would have let me know that then.
I'm sorry, I can understand you.
I said she just accepted my motion like yesterday or the day before. I'm trying to figure out why did she take it and not let me know that? Like,
I got no idea.
Because I keep my case in a maze. Like, I don't even know who to file to. Like, I'm trying to figure out what's going on.
Welcome to my world.
Yeah, been in it for a little minute. So
all right,
I go, but
we'll set it for April 17th at 9 o'clock, and Mr. Sullivan, he can contact, if he's representing himself, contact your office or contact Mr. Sullivan. Okay.
You said Mr. White.
Mr. Sullivan is the supervising attorney, so that's who you want to talk to right now. Not today. He's got a bunch more to do, but that's right now.
Mr. McCoy.
Mr. McCoy, if you'll sign that notice. At 1:30. All right, Mr. Cruz,
Things start heating. Up when Mr. Cruz makes the call. Meanwhile, McCoy's still in the dark. He doesn't even know who the state attorney is. It's like preparing for a legal fight without knowing your opponent. The court's trying to help, urging him to contact senior attorneys for guidance. But the whole process is a tangled mess of confusion and red tape. Still, the judge moves things along and sets a firm date. April 17th for the motion hearing. No more delays. No more guessing. Then Cruz calls again, giving McCoy one last out. You can still get a lawyer. But McCoy stands firm. No backing down, no legal team, just him. This isn't just a hearing anymore. It's war. And McCoy's walking in alone.
Mr. McCoy, come on up. I'm going to go ahead and call your case. Mr. McCoy, you've made the decision to represent yourself. You understand at any point in time you'd like to have an attorney appointed to represent you. One could be appointed to represent you. Is that correct?
Yes, sir.
And we're set today. We got a notice of hearing. Second motion. You said this motion. Yes, the second motion to compel.
Yes, sir.
All right. Go ahead, Mr. McCoy.
So, Your Honor, it's gonna be hard for me to move forward in my case without those my videos or that evidence. So, that's the only reason I'm putting in my second motion to compel. And I'm just saying without it, it's hard for me to to have a defense. Because that contains all my defense. So that's pretty much.
So at this point,
He's asking, I guess, let me separate them out. He's got a motion to compel the cameras from the store.
Which we've dealt with several times before.
I can't compel those. I mean, you haven't noticed those people. They're not law enforcement. They're not required to save those tapes. They're not required to send them in. I don't know if you've requested it from them individually.
I did, but they said it had to be done through y'all.
Yeah, well.
Here's where things heat up. McCoy files a second request asking the court to force the release of video footage. He argues he can't properly defend himself without it, but the state quickly pushes back. They say the videos come from private businesses, not police sources, so there's no legal duty to turn them over. If McCoy wants them, they tell him to issue subpoenas and get law enforcement involved. Even then, police aren't required to go out and gather that kind of evidence. The legal back and forth is intense. Without the videos, is a fair trial even possible? That's the big question.
You'd have to, if you were going to do that, you'd have to notice him. I think I've already told you.
I sent a subpoena in. He answered with me in the owner talk, but they said they also need some law enforcement to come in to get the video.
That I can't direct law enforcement to do an investigation. That's not my job.
The attorney already went up there. She just didn't get it. She says she went up there anyway. The one that I had.
Miss McAfee. This is a separation of powers. I don't direct law enforcement to how they conduct their investigations. Now, also, I think there was some cam recorded. If I remember correctly, recorded.
Body cam footage.
Yeah.
You've not received any of those? No. Okay. There are 3 discs here. It's got, my understanding is cameras from FHP. They're written on here. FHP videos, and then cell phone extraction is the 3rd disc.
Okay, so what about the camera footage from Bay County? That's the ones I actually need.
Those are the only
FHP was only, they said they was only assisting Bay County. Bay County is the ones that the case is actually against because there were
no body cams from those officers. These are the only body cams that
they had body cameras on them. And I need that footage.
Get even more tense. McCoy demands footage from Bay County officers, the ones directly involved in the case. But the state pushes back again, saying those officers didn't have body cameras. Only the Florida Highway Patrol did. McCoy does receive some FHP video and phone data on discs, but that's all. The court reminds him they can't force private businesses to hand over security footage. McCoy's frustration hits a boiling point. He's left with scraps, and it's nowhere near enough. The system's tough, and he's caught in the middle of it.
And as far as the store video, that's where the crime scene took place at. I figured
that is a private, that's a private organization. I can't order them to release information or to get that. I don't have any jurisdiction over them. I can't just.
According to Rule 37, Your Honor, you can't just not give me my videos, though. I'm pretty sure the officers got the videos because at the stores where the crime scene took place. You're pretty sure, but I can't, if they say they don't have it, if they say they don't have it, I can't make them. I can't make them say something they don't have. So that motion is denied. Do you want some time to look at those? This ain't gonna do me no good.
Do you want to go ahead and set it for trial?
I'm setting it in for a hearing, and I'm gonna put in my motion to dismiss. I'm gonna go to trial without my evidence.
We'll set a motion to dismiss. That'll be May 23rd at 9 o'clock. Okay.
I file all the paperwork.
Very good. You step up and sign a notice.
Well,
if you got a notice, they're going to have you sign a notice, Mr. McCoy. All right. And see, Mr. Sullivan, you covered for Mr. Graham.
Yes, Your Honor.
Okay.
Mr. Myers is here in case number 22-4842 and 22-4840. He's set for a Nelson hearing.
All right. If you'll swear Mr. Myers in.
The judge has had enough. McCoy's motion to force the release of evidence is denied. End of story. The trial is officially set for May 23rd at 9:00 a.m. The court orders McCoy to complete his paperwork and sign all required documents. No more stalling, no more excuses. This case is going forward, ready or not. The pressure's on, the deadline's set, and if McCoy wants a shot at justice, he'll have to step up and fight for it.
You're about to treat.
Yes, ma'am.
All right, sir, you're asking to have your attorney replaced, is that correct?
Yes, sir.
You wish to proceed with that motion?
Yes, sir.
You may go ahead.
I, defendant George Myers, pursuant to Blanding versus State, moves this honorable court to discharge counsel Kristen Piazza due to counsel's incompetence and ineffectiveness from current representation. In support thereof, defendant states that 1, this is that this is an unequivocal request to discharge counsel. 2, that counsel is incompetent. And 3, that counsel's deficient performance arises from her current representation and not from past indiscretions, and is as follows. Counsel is incompetent and not adequate assistance of counsel guaranteed by the Sixth Amendment. Counsel's continued representation would be ineffective assistance of counsel and will result in misjustice and an unfair trial. Counsel communicates with defendant at a bare minimum, does not keep defendant reasonably informed about status of prosecution. The defendant has only had one attorney visit where his co-counsel is present and has had no current communication with her and would like a second non-biased opinion. The defendant believes counsel is biased towards his charges and does not have defendant's best interest in mind. Counsel waived defendant's right to a speedy trial without defendant's consent or even discussing reasoning with him. Defendant does not believe that his lead counsel meets the requirements set forth in Florida Criminal Rule Procedure 3.112, the minimum standards for attorneys in capital cases, specifically 3.112F, lead trial counsel, and 3.112J, limitation on caseloads. Also, counsel does not abide by a client's decisions by refusing to file a double jeopardy motion after defendant showed grounds and reasoning for motion. Also, counsel had previously agreed to file a motion and now claims that she'll get in trouble for writing a meritless motion. Therefore, she lied to the defendant. Counsel failed to show due diligence by not researching double jeopardy violation and a complete lack of willingness to do so. In order to better understand defendant's claim, the defendant would move this court to take judicial notice of the following relevant case law. Carlson versus State, which is 405 SO2D 173, Chictus versus Shands, which is 373 SO2D 904, Witcher versus State, 737 SO2D 584, Brown versus Ohio, 432 US 161, Harris versus Oklahoma, 433 US 682.
Now let's turn to George Myers. He's demanding a new lawyer, saying his current one isn't doing the job. According to Myers, there's been poor communication, serious mistakes, and even a move to waive his right to a speedy trial without his permission. He's not holding back. With a list of complaints and legal references in hand, Myers is ready to fight for a fair chance in court. This is real, unfiltered courtroom drama, where the accused is pushing back hard and the system isn't giving an inch. You'll want to keep your eyes on this one.
Yeah, is that it?
No, sir. And as in the above cases, the defendant has already been adjudicated guilty in cases 22-CF-1576 and 22-CF-1599, and is now being prosecuted again for the exact same offenses and also for greater offenses that necessarily include the lesser offenses for which the defendant has already been convicted of. The defendant has additional oral arguments to support his claims and will also move this court to allow rebuttal arguments to counsel's response to his claims, since the burden to replace and discharge counsel lies with the defendant.
Anything else?
Yes, sir.
Ms. Piazza's response.
Yes, Judge. I believe the main issue that merits response is Mr. Myers. I think his main issue is the lack of the motion that he wants filed for the double jeopardy claim, and so I think that comes down to two issues. What he's saying is the lack of research and then the lack of filing the motion. He's provided me pages and pages of case law. I've looked at all of those. So I have diligently researched that issue. And I've also had in our office, we have somebody who does research for us, kind of like a paralegal who does research, and he's done extensive research on this issue as well, which I've discussed with Mr. Myers. He just doesn't like the decision that I've come to based on all of the research. And it was never my intent to promise him to file any kind of motion. It was more of an intent to, I will absolutely look into this. If there is a motion, I will absolutely file it. And that's still my stance, that if I ever do see a motion in this case, I will absolutely file it. But at this point, I don't see it, and I can't file a motion that has no merit because that would not be the correct way to move forward with the case. And that is why I have not. So I'm not sure if there's any other issues that you would like me to address.
I'm going to deny the motion. It's up to Ms. Piazza whether to file the motion. that you're asking her to file. It's also up to her whether to waive speedy trial or not. So I'm going to deny your motion. We need another court date. Where we at? We ready to set
myself then, sir?
Is he already under oath?
I haven't sworn.
Pardon?
I didn't swear.
He just made an argument, didn't he? All right, we'll swear him in.
You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth to help you God.
Yes, ma'am.
All right, Mr. Myers, state your name.
George William Myers?
Mr. Myers, you've asked to represent yourself. Is that correct?
Yes, sir.
You understand that attorneys are trained in the rules of evidence, criminal procedure, and the
The defense team isn't taking Myers' accusations lightly. They fire back, saying they've done their homework and made strategic legal choices for solid reasons. According to them, filing weak or baseless motions would only hurt the case. The judge steps in and makes a call. Myers won't be getting a new lawyer. The trial is moving ahead as planned. Tensions are sky high. The courtroom's become a battleground of legal arguments and sharp tactics. Myers looks exhausted, and if he chooses to go it alone, he's taking a serious risk. This isn't just a legal fight. It's a high-stakes gamble.
they're trained on what motions to file and what motions not to file. Do you understand that?
Yes, sir.
They're there to prepare you, to prepare the case for any pretrial motions and also prepare the case for ultimately a trial. But just answer my questions.
Yes, sir.
Do you understand that?
Yes, sir.
You're charged with first-degree murder, which is punishable up to the death penalty, if all possible. But at least the minimum on a first-degree murder is life in prison. You understand that? Yes or no?
Yes, sir.
You understand if you're convicted of first-degree murder, that the least sentence you could get would be the remainder of your life in prison. You understand?
Yes, sir.
And you understand if you do represent yourself, you'll be held in the same standard that an attorney is held in. You understand that?
Yes, sir.
Are you under the influence of any drugs or alcohol today which would impair your ability to make this decision?
No, sir.
Have ever been diagnosed with any mental illness that would prevent you from making a decision in this matter? You understand if I find you competent to represent yourself at any point in time, you can ask an attorney to be appointed to represent you.
Yes, sir.
All right. All right, I am going to find that Mr. Myers is competent to represent himself. I'm going to allow him to represent himself. I'm going to allow the public defender's office to be backup counsel. That does not mean that Ms. Piazza is obligated to give you any advice or to help you in any way until she's appointed to represent, unless she's appointed to represent you again. You understand?
Yes, sir.
All right.
Yes.
All right.
He did already have a court date. He had 2 court dates, but those were both based on my representation and that I'm going to be out for a little while, so I don't know if those will change now that he's...
We'll leave it set for a jury trial July 7th and trial management May.
At last, Myers is officially sworn in to represent himself, fully aware he's facing first-degree murder charges that could lead to life in prison or even the death penalty. The judge doesn't sugarcoat it. Without a lawyer, Myers has no safety net. If he makes a mistake, he'll have to live with the consequences. His mental competency is reviewed and cleared. Against all odds, Myers insists he's ready to take control of his own defense. A jury trial is scheduled for July 7th, with a trial management hearing set for May 23rd. This case is headed straight for a showdown. No more pauses, no more protection. It's all or nothing from here on out.